absolute expert on the existing laws are said to be hindering businesses as well as preventing investors from coming to Nigeria. It is for this reason that the National Assembly engaged the private sector to come up with ways of addressing them to facilitate economic growth of the country.
A lot has been said, severally. A lot has been said about what it will cost this country to fill the infrastructure gap, but in our view, nothing has been done in terms of that this sector, the laws that are relevant to these sectors are passed. For instance, in the power sector, we have the Powers Act of 1954 that later became the NPA Act. When the BP was commercializing, in 1992, it became Nigeria Post PLC. Subsequently, it became the Nigeria Post Authority Act. Essentially, this bill, this law, has remained the same since 1954. In the rail sector, we have a Railway Act that was passed in 1955. This law has remained substantially the same as we speak. And so, these are laws that were passed at a time when government was the sole provider of what we call public utilities. It's become clear that government does not have the resources. From this slide, it's expected that 52% of the funds for this sector will come from the private sector. I think that is much more than 52%. It's also clear that in the private sector, there's the expertise that is not available in the public sector. And so there's the need to cooperate and there's the need to reform. For us, reform is imperative. The Privatization and Commercialization Act was passed in 1988. Since 1988, we have been moving from public monopoly to private monopoly in this country. And yet, we don't have any regime on competition. Since 2000, there has been a bill on competition that has been moving within the National Assembly and Executive. I'm sure it's one of the oldest bills in this House. We think that it is time for that bill to be passed so that we have a proper regime that will control this area of the economy. Now, what is the scope of our assignment? The scope of our assignment had three main scopes. First, for us to review the current and proposed laws that are relevant to the business environment. We have done that. In our review, we identified the gaps and the deficiencies in the laws. We did that. We made recommendations. Your Excellency, distinguished guests, ladies and gentlemen, it gives me great pleasure on behalf of my team to present to this House our recommendations, which will be addressed by this roundtable in conjunction with the National Assembly and the private sector. As has been said, we are of the view that if our recommendations are taken into account by this 8th National Assembly, it will be a major achievement by this assembly. Now, how did we carry out our assignment? In research, you carry out legal research, either is doctrinal or non-doctrinal. But in our approach, we adopted the doctrinal. And we did this by looking at the World Bank indicators. Now, I'm sure everybody here knows that Nigeria is ranked 169 out of 189 economies. But not many of us are bothered to ask, why is our ranking that low? As you see shortly, small countries like Mauritius, like Rwanda, Ghana, they rank very high. In fact, Mauritius is 32 over 189, Ghana is 114 over 189, and Nigeria is 169. Why is Nigeria ranking low? We look at the World Bank report and look at the indicators, which we will discuss very briefly, and see the impact of the indicators on the other laws of this country. In 2013, SMIDAM and Nigeria Bureau of Statistics carried out a survey, and we look at the survey to guide our assignments. Last year, The Ministry of National Planning published what it refers to as the National Integrated Infrastructure Master Plan. That master plan has to do with infrastructure in this country. We also look at the Vision 2020. And we were guided by the scope of work and objectives of the assignment that you will find in the report. Now, in the review, we found that the current laws of Nigeria are in 14 volumes, and the laws are about 407. We also look at the bills pending in the National Assembly. And we said, for our work to be appreciated, we'll have a format for the presentation of our review. And our format is to identify the name of the act and look at the long title. Why are we looking at the long title? The long title of the law tells you why that law is being passed and its sure is creating. The same thing with the explanatory memorandum. When we look at these two, the long title and memorandum, we're able to identify laws that are business related and those that are not. What are the institutions created by these laws? We examine them, we identify the gaps, and make recommendations. Now, at the end of the exercise, we rank this review into high, medium, and low. The high, those who rank high, are those who consider very, very urgent that should be addressed by this National Assembly. Now, we talk about doing business report, and I like this quotation from a doing business report in 2016. It says, for policymakers, try to improve their economy's regulatory environment for business. A good place to start is to find out how it compares with the regulatory environment in other economies. Also useful to know how it ranks relative to comparator economies and relative to regional average. You will find in our report that in the case of Nigeria, we use Kenya, India, South Africa, and the UK. I also found regional average. And what the World Bank does is to pick commercial cities in the world. Now, we like to know that in Nigeria, Abuja was not used for this study. They picked commercial cities. So for Nigeria, they identified Lagos State and Kano State as the commercial cities. Now, because they picked states and not Abuja, the federal capital, you know that state laws had a major role to play. So, in looking at why we are doing badly in Nigeria, we must look at the laws of Lagos and Kano states and see how they impact on this sector. Now, it's getting harder to do business in Nigeria. Instead of talking, saying, doing business in Lagos and Kano states, as if Lagos and Kano states represents Nigeria as a whole. They are looking at processes, they're looking at regulations, they're looking at practices and procedures, not essentially laws. Now, they are worried about time, the duration, and the procedure. So, we're talking about company formation. They're not looking at whether we have PAMA. No, but how long does it take to register a company? How does the company perform? So, we make a submission at the end of this presentation that for us to improve on our ranking, because state laws have a major role to play, we need the collaboration of states to ensure that we do better than we have done in previous years. Doing business has been on since 2005. In 2012, 2014, 2015, this is based on 189 countries. In fact, in 2015, we did fairly well because we moved from 170 to 169. And what are the indicators? These are the indicators. There are 10 indicators that the World Bank uses in assessing how a country does well. Starting a business, we scored 139 out of 189. Dealing with construction permit. So this slide shows our score. It is the aggregate of these scores that gave us 169 out of 189. We are saying that this is totally unacceptable because Nigeria should improve. And what we find interesting is we have similar laws as other countries, but the difference is in regulations, processes, time, procedure, and challenges in the system. Now, our first key finding is to say, like I said earlier, is that we need to improve on our regulations. We need to improve on our procedures and practices. Now, some federal laws may impact on this, like CAMA. We will talk about CAMA very shortly, and other tax laws. But the main areas to focus on is state laws. Now, we'll talk about the fact that the laws of Lagos and Kano were used. Let's look at a couple of the findings. Starting a business. From the report, it takes 5 days to get a name reserved in Nigeria. And they're talking about Lagos or Kano, not Abuja. 7 days to incorporate and pay stamp duty. And 11 days to register a company. Now, look at the UK. In the UK, in 24 hours, you can register a private company online. But if it's by postal registration, it takes 8 to 10 days. Now, you ask yourself, why does it take 5 days to do a name search in an era of IT? Why can't you go online to do a name search? Why do you need to wait for 5 days? Now, you also find that in preparing the documents of a corporation, there are challenges in Nigeria that are going to do with the law. For instance, in 103 countries, out of the 189, there is no more requirement for minimum share capital. Why do you need a minimum share capital for a small company? I'm aware that the Law Reform Commission even recommended that this should be increased. Our view is we do not need a minimum share capital. At the very worst, we should reduce the minimum share capital. Now, if you look at section 18 of CAMA, it says to start a business, there's a minimum of 2 or more. Now, we know that most private companies, even where they employ 200 people, is one man and a son, one man and a wife, one man and a daughter. And the man calls it my company. He doesn't care that it's incorporated, my company. So what you find is, it's really one person running these businesses. Why do we not say in our purpose that one person can form a micro company? Why do we need 2 people to form a micro company? Because like I said, they see them as their companies, and they are run by one person. CAMA provides that you have annual general meeting. The man will stay in his office and draft all the resolutions and file them. Now, whatever is done, we know this. But why are we comparing for the big companies? For the public companies, we don't have any problem. Our focus is on those who employ 10 people, 50 people, 20 people. Why do we have provisions that are so enormous for them to cope with? Look at section 54 of CAMA. It says to do business in Nigeria for a foreign company, to do business in Nigeria, it must register as a Nigerian company. We ask, what is the meaning of doing business in an IT era, where you can stay anywhere and do business in Nigeria? We have heard the fact that CAMA was passed in 1990, and so overdue for review. There are several areas, like even filing of returns. To file annual return, you need to appoint auditors. How many small companies can appoint auditors? So there are provisions in CAMA clearly that are against small businesses that we need to look at. Getting electricity. When you see this, you think it's power supply they're looking at. They're looking at power supply. They're looking at the procedure for getting connected. Now, this is Lagos State. It takes 44 days to submit an application form to a coal distribution company. It takes 31 days. See, all these days are indicated. They are all from, this is why we score so low. When it takes so long to get, not like I said, it's not the supply, whether we have, no. The procedure for getting electricity. Trading across borders. Trading across borders. Now, although we have laws in this area, the laws are caked. In fact, our score here has to do with compliance and documentation. Our documentation is largely manual. Why can't we automate this area. Enforcing contract. Now, it takes 409 days at a cost of 7% of the claim to enforce a contract. We are saying that the chief judges of the states are empowered to make rules of practice. Why can't they use their powers to provide for commercial courts like you have in Lagos State, small claims court, and pretrial conferences? Now, a lot has been said about ADR. But since 2007, there has been a bill in the National Assembly to update our Arbitration and Conciliation Act. My colleague said will remind me that we have the Arbitration and Conciliation Act of 1988. We say that there's a challenge with that bill. Now, on 11th March 1988, when that act was passed, we are running a military regime where decrees were superior to the Constitution. So from 1988, that law was applicable. And in fact, if you look at section 58 of the law, it provides that it shall apply throughout the Federation. It was good law until May 1999. From May 1999, when we had a constitution, you look at the exclusive list, look at the concurrent list, you will not find the words arbitration or conciliation. Which then means that arbitration and conciliation are residual and therefore matters for the state. That is why some people argue that, look, it is only states in Nigeria that can make laws on arbitration and conciliation. Some of us agree up to a point, to the extent that when it comes to interstate transactions or international transactions, it's only the federal government that can make laws of that. So when Chibayo JSAN was at the region in 2006, instead of a committee, I was a member of the committee, to review these laws, and we drafted 2 laws. One for the federal government to deal with interstate disputes, international disputes, one for state government to adopt. From 2007 to now, only Lagos State has passed that bill of 2007 to law. This 1914 Act was based on the 1889 Act of England. In England, that was repealed in 1950. There was another version in 79. In fact, in 1996, English passed a new Official Act. Meanwhile, most states, and I'm really ashamed to look at laws of some states, you should see the 1914 arbitration. It was an ordinance in 1914. It is the 1914 ordinance that's being used. So we are saying that there's a need, 2007 start from now, there's a need to look at that law that was passed then, update it, and add it to the laws we passed. Payment of taxes, this one area we have done very badly. From the World Bank study, you find that in Lagos and Kano State, they have up to 18 taxes or mandatory impositions. 18. Now, we ask ourselves, if these taxes are based on income or profit, why not have one tax base? Instead of collecting for PTDF, you are collecting for this, you are collecting for this, you are collecting, and it's a burden on these small and medium enterprises. So there's a need to streamline our tax processes. Now, let's look at the laws with regard as key that, in our view, must be. For us today we are entered into an alliance with the National Assembly. We are saying today we are seated in setting an agenda, and that at the end of their tenure, we will judge them by how far these 15 bills have been passed. I talked about the completion one earlier. The number two National Commission bill. Now, what we are having is, let me go to the polls. I was general counsel in BPE when the reform was done in 2005. At the time we did the concession in BPE then, it was envisaged that the post and post bill will be passed to provide for technical and economic regulation. Now, there was a draft bill in the National Assembly in 2005 that up till now is not passed into law. Meanwhile, we did the reform of the ports without a regulator. I'm aware that the Shippers Council, when I was there, we argued that Shippers Council is not properly equipped to carry out either technical or economic regulation. But the Shippers Council today is the regulator for this sector. We urge this National Assembly to pass the Post and Apples Bill so that we can have a proper regulator for the port sector. Now, I'm glad to talk here about the petroleum industry bill. Again, that is a bill that was evolving as a PPE from 2004. Now, the challenge I have with that bill is what we'll measure very shortly. Most bills here, there are various versions of them. We ask ourselves, why do we wait till public hearing before we know that there are various versions of a bill? In fact, at the point, at National Assembly, when you ask PIB, say which version? Because there were several versions. But the one I saw last was the one that the former Minister of Petroleum endorsed every page. Now, when you look at that bill, and you look at the NCC Act of 2003 and the Electric Power Sector Reform Act 2005, you wait for this country. Now, we're talking about the concept of independent regulators. Independent regulators. Look at the NCC Act. What is it about regulation? Look at the Electric Power Sector Reform Act that created NEC. For an independent regulator, all you need to do in the bill is to provide for the qualifications of those who are going to be commissioners. Don't list their offices. We achieved this with the NCC bill, NCC Act. We achieved this in the Electric Power Sector Reform Act. But the PIB that I saw last, the powers given to the minister under that bill are enormous. Two, they created two regulators for upstream and downstream. And who are the members of this body? Representative of Minister of Finance, representative of the Minister of Petroleum Resources, NUPENG, PECASI. These are those to be regulated. They are those who are members of the body to I can't understand. I really can't understand. So we need to look at this bill to see who are the regulators. Who are the regulators? I mean, how can NUPENG regulate itself? How can PECASI? So these are things I think we should look at. The Independent Warehouse Bill, I know that I'm pressed for time. Why I like this Independent Warehouse Bill is one major challenge of the MSME is access to finance and access to land. In terms of access to finance, the Land Use Act has not been too helpful to them. Because from the time this act was passed in 1978, it became an existing law in the 1979 Constitution. If you see an existing law, there's a challenge. Until we remove that act from the Constitution, we will continue to have problems in terms of access to property in this country. What is also interesting, the governor's consent, the procedure varies from state to state. So if you cannot take that law out of the Constitution, there should be a simplified procedure for obtaining the governor's consent. So what this Independent Warehouse Regulatory Bill has done is, okay, use your warehouse receipt as collateral for loan. So if this bill is passed, you find that the private sector can use their warehouse receipts as collateral for a loan. The Secured Transactions in Movable Assets Bill. Under this bill, there will be a registry, Movable Asset Registry. Here, you can use non-fixed assets as collateral to get a loan. The National Development Bank, at the moment, we have the Bank of Commerce and Industry, we have the Bank of Trade and Commerce, we have the Nigeria Economic Recovery Fund. What this bill is to do is to consolidate all these laws to make access easy. Franchising bill, I find this very key for the small enterprises. Now, today, the small enterprises will enter into a transaction with a foreign company that is more powerful. So they give you a template, you sign, and that's it. But under this bill, there's a provision for what should be contained in every franchise, so that the terms are not too onerous on Nigeria. So if this franchising bill is passed, it will assist the small and medium enterprises. I'm talking about Kama. Let me quickly move on. Let me not abuse the privilege that I was given by the chairman. Now, this is our last slide before I round up. What are our key recommendations? We are recommending that at the National Assembly, we should have a federal legislative clearing house. Why are we saying this? we found several laws that have created institutions with overlapping and conflicting mandates. It creates problems. We'll start with the ICRC Act and the Bureau of Public Procurement Act. Now, the Public Procurement Act deals with the procurement of works, goods, and services. The ICRC is concerned with PPP transactions. Then you ask yourself, is a PPP transaction procurement of works, goods, or services? We can say that in terms of engaging transaction advisors, yes, you go through the PPP. But when it comes to pure PPP transaction, when the private sector operator is going to use his resources, why should that go through the Bureau? And we also have a challenge with the Bureau of Public Procurement. Your Excellency, one challenge we found in the course of this job is the oversight function should extend to how laws passed by this National Assembly are being implemented. In July 2007, the Public Procurement Act was passed. Section 1 provides for the establishment of the National Council of Public Procurement. Your Excellency, we are aware that from 2007 till now, there has been no National Council of Public Procurement established. Meanwhile, the Bureau has been operating. They've been issuing thresholds, they've been issuing the certificate of no objection. Now, under whose authority do they issue those thresholds? Every Wednesday, they go to the Federal Executive Council meeting. There's no reference to FEC in that act. And our view is, we do not see why FEC should be approving things that are being done. FEC is an alien to that law. So we think that that council should be set up to validate what the Bureau has been doing. There is also overlapping function between PPE and ICRC. Now, the PPE Act was passed in 1999. ICRC Act was passed in 2005. Now, some of the enterprises listed for either privatization or commercialization are also listed under the ICRC Act for concession. Now, if you are, and what normally happens is, these foreign investors, they engage some of us to advise them on our laws before they invest. Now, if you are asked by an investor, which organ of government regulates PPP? Are you going to say PPE or are you going to say ICRC? But ICRC has cured one major defect in the sense that it provides in Section 1 that from the commencement of this act, any ministry, department, agency engaged in the provision of infrastructure can enter into a concession or grant a concession. So the defect in laws that do not provide PPP are cured by the ICRC Act. But we are saying that because of the overlapping mandate, there's need to reconcile these two laws. Now, I'm glad that the DG of CPC is here. There's also overlapping mandate between the functions of the CPC and other agencies. Consumer protection, you have provision on that in the Electric Power Sector Reform Act. You have that in the NCC Act. You have that in some Act. You have that in NAFDAC Act. So, when it comes to issue of consumer protection, there's always a conflict between the CPC and these other laws that provide. I also found, too, that in the Minister and Mining Act, there's provision for environmental issues, which are handled by NESRA. So we are saying that when you have a body that is trying to carry out one particular service, why do you duplicate that in other organs of government? And the tax appeal tribunal is an issue that we consider. Now, before 2007, there was no such tribunal. The tribunal was created under the Federal Inland Revenue Service Act. Since its creation, there have been problems with this mandate. You look at Section 251 of the Constitution that provides that tax matters is within jurisdiction. Christy is telling me, Your Excellency, Christy is telling me that my time is up. We need to save the functions of the TAT by looking at the Constitution. We think that the TAT is a specialized court. It should be allowed to do its work. If it means amending the Constitution, we think that that should be looked into. Now, We also think that there's a need to have a forum for National Assembly and State Assemblies, something in the neighborhood of the Governor's Forum, where all these views can be articulated. For instance, we are saying that there's need for collaboration between National Assembly and State Assembly for Nigeria to score highly in the World Bank ranking. Which forum do we have to carry out that assignment? We think that, and thank God, the National Economic Council is leading now. We also think that, although we agree that National Assembly is not a member of the Council, there is one other venue where this issue of our ranking can be addressed. So we know that the problem is not essentially federal, the problem has to do with state. We will talk about taxes. Let's quickly round up by looking at the Constitution. Section 44, sub 3, deals with vesting the title to mineral, mines, and petroleum on the federal government. We are saying that while we may concede that petroleum products will be linked with federal government, mines and minerals should be taken out of the Constitution. Because if you go to states like Taraba, Plateau, Benue, where you have mines, the locals, they survive on this. These are these small investors. There should be a way of formalizing what we are doing instead of saying that they must go through the process. We think that that should be emphasized. We talked about Section 251 earlier. Section 315 question deals with existing law. Here, we are concerned with the Land Use Act and the Arbitration and Concession Act. Newer Act, if you look at the exclusive list, and you look at item 36B and 64, it deals with newer. Now, expressly, that item deals with inland waters between state and international. Lagos State is arguing that that item does not cover waters within states. We think there's need to look at that.